Hi, good afternoon, everyone. This is Rajiv S. Khanna for immigration.com, the law office of Rajiv S. Khanna PC. This is our bi-weekly community conference call where we try to answer the questions presented. Um, Remember, as you heard when you were logging in, this is not an attorney-client privilege telephone call. It does not create a relationship between us. And we try our best to answer the questions with the information that we do have. This is not a substitute for a one-on-one consultation. I'll first answer the questions. There's a couple of questions I have marked as frequently asked questions. Invite follow-ups on just the frequently asked questions. Then put everybody on mute again and go through all the posted questions. Then invite follow-ups on the posted questions. After that, I will invite new questions. Okay? So let's get started. Let me go to my questions that are already posted. So there's a question about visa denial based upon immigrant intent, which is section 214B. See, 214B denials typically you will come across in student visa applications, tourist visa applications, even J1, J2 applications. They can be problematic because they're very difficult to overturn. It is a matter of subjective determination of the consulate that they suspect the applicant has an immigration intention. The question that is posed for me by Swarna 691991, my F1 visa was denied twice for 214B. I have visited my uncle for 6 months on a vacation. But that's a good sign. If somebody has come to the US on a tourist visa or any other non-immigrant visa and gone back within the time permitted to them, that's a good sign. That kind of shows that you are somebody they should trust. So in a case like yours, unless there was a reason for the consulate not to trust your submission, they should have considered your case more sympathetically than the case of somebody who's never been to the United States. Okay, so you are planning to appear again for F1 visa with your parents' sponsorship. I don't think the sponsorship is a problem. First time around, it was the uncle's sponsorship. I do not know that that was the issue. I don't think so. Do I have any suggestions that will improve your case? I would just, if given an opportunity, I would point it out to the government that I've been to the US before and I've never violated any US laws. I've come back within time. So you could certainly, if given the opportunity, make that comment. Other than that, I'm not sure you can do anything to improve your chances. Okay. 214B denials are always problematic for this reason. They are difficult to overcome. We have been successful in one or two cases in the last 20 plus years. Of course, we've taken very few of these cases, and we take them only when we feel there is some argument to be made that your case should be considered sympathetically. All a lawyer can do is send out a letter after a denial saying, please look at this case again. There are reasons this case should be reevaluated. And like I said, rarely consulate may decide to reconsider your case. Next question is also, set of questions is also about a very frequently encountered and misunderstood issue of job portability under AC-21. I'm going to take a couple of minutes and tell you about what it is today, what President Obama wants to make it, and how that would be very beneficial for us. Today, the way it works is an AC-21 portability was basically enacted by Congress back in 2000, October 2000, under a law called American Competitiveness in the 21st Century Act. The kind of an abbreviation or acronym for that is AC-21, American Competitiveness in the 21st Century Act. What does that say? If your I-140 is approved and your 485 is pending, whether it was filed with the I-140 or after I-140 approval, if it has been pending 180 days, you may change employers to any same or similar job anywhere in the United States, and you will not have to do your green card again. So basically, you can port your job over as long as it is same or similar. Tricky problem. What is same or similar? No one knows. If you are a software engineer and you remain a software engineer on the next job, same or similar. Okay. If you are a software engineer in the next job and you become a IT manager in the next job, maybe not so sure. Okay. This is where Obama steps in and he says, look, I will make it clear for the record that natural progression in a job does not take away from it being same or similar. That's the first thing President Obama wants to do, and hopefully they'll implement it fairly quickly. So natural progression is considered to be same or similar. Second thing President Obama wants to do is to let you file I-485 without the priority date becoming current. So that means you will earn the right to an AC-21 almost a year and a half, 2 years into your green card process, which is very good. Right now, if you're India born or China born, you could have to wait many years before you earn that right. So that's in a nutshell AC-21. Further down, somebody has asked me a question today. Do we have to inform USCIS? Well, the interesting thing is that there really is no formal process for implementing an AC-21 transfer over job portability. Basically, you're not required to file a letter, but we usually have employees, individuals in that situation, file a letter, inform USCIS, because USCIS is prone to making mistakes. Sometimes, if the old employer revokes your I-140, if you are an AC-21 eligible individual, it does not make any difference if the employer revokes the I-140, as long as you cross the 180-day deadline. Even if they revoke, you're entitled to your AC-21. Okay, but the problem is USCIS sometimes is not aware of the nuances of the law, especially the less trained officers. They could revoke your 485 or send you a notice of revocation, and next thing is you're running around trying to solve this problem. And if the AC-21 is revoked, you are immediately unlawfully present. You can't work. Well, work is debatable, but let's just say you are unlawfully present, and it's just a whole lot of mess that should be avoided. And that's why I also advise people to keep their H1s active. So AC-21 letter should be sent. And somebody has asked me further down, I remember this one, reading it just a few minutes ago, should we be hiring a lawyer? Please do not do this yourself. Many things I'm okay with people doing themselves. You may be okay, you may be able to get through it okay, but it's not worth the shot, worth the chance. It's just the downside is too terrible. So get yourself a lawyer. Don't do it yourself. That's what I would recommend. Now, the questions that are before me, GO 2008 says, my I-485 based upon EB-1B is pending more than 180 days. If I decided to change job under AC-21 rules, should the job description be the same as my definition of EB-1B, or should it match my current job description? Current job description. If you're trying to take advantage of EB-1B portability, AC-21 portability, your job description should be same or similar in relation to the job description that has already been filed. Okay. Do you advise on changing EAD or transferring H-1B? I told you H-1B is better. Do it and H1, keep your H-1B alive. Based on your experience, will you advise to change jobs under AC-21? Yes, if you have a good opportunity. We have done hundreds of AC-21, if not thousands of AC-21 cases over the last few years. We've never had an issue. As long as the jobs are same or similar, you should be fine. Okay, I want to invite follow-up questions on these two frequently asked questions that I just discussed. If you have a follow-up question, no new questions, nothing else, but follow-ups on these two issues that I just discussed, 214B denials and AC-21 portability, please press *5 on your phone. *5. Any follow-up questions? One question from New Jersey. Any follow-up questions? Press *5. Okay, let me take New Jersey. New Jersey, go ahead. I can hear you.
Yeah, this is Khanna here. I have posted similar question for AC-21 problem sort of issues. I guess my question number is 21. And I have similar problem like my green card employer who is processing my green card has revoked my I-140 after 2 years of the duration. Now at this point of time, my EAD is for renewal and it is due on like April 26th of this next month. So would there be any
Pranavji, I'm looking at your question. It's number 20. It says working for company one. Okay. Approach company 2 and 3 to port the date, out of project, apply for EAD renewal. For EAD renewal, I do not think you will have a problem, but you should file an AC-21 letter anyway. I don't think you need to panic, but I do think you need to act quickly. So if within a week to 2 weeks you can file your AC-21 letter, I think you'll be okay. My problem is USCIS, ignorant of its own procedures and law, can sometimes put you in unnecessary trouble. Okay, but here's the good news. Last 8 or 9 months or so, I have not seen people get into trouble. Before that, it was relatively frequent that when the I-140 is revoked, they would automatically revoke the I-485 illegally without giving you a chance to explain. Now what I'm noticing is that they send out a notice of intent to revoke. They'll send you an NOIR saying, because your I-140 is revoked, you are no longer entitled to 485 unless you are protected by AC-21. If so, provide documentation. So they are inviting documentation before they revoke your case. So I'm not that concerned about it. Two things you need to remember. For your EAD, this probably is not going to be an issue, but you should file your AC-21 as expeditiously as you humanly can. I would advise that on both counts. Okay.
Yeah, if you look at my case, that my employer revoked the I-140 in May 2014, and it was up till May 8 August 2014. And I'm not sure, like when I checked the case, they said that they sent out some certain documentation, and I haven't received any documentation. Maybe that documentation went out to the employer. Now, since the employer revoked it, he never shared anything with me. So I'm like, if they're expecting me to 21 documentation to support our loan, if they send a MOIR notice, would it come to me or to my employer? Who would that notice come to?
It would go either to you or to your lawyer, not to your employer, but to your lawyer. So what you need to do is make sure your lawyers have your most recent address. If you don't have a lawyer, for the process, make sure you contact USCIS for the customer service. Point it out to them. You don't have a lawyer, and you need to be sent a copy of everything directly. Okay. And if you have any indication that there is an NOIR that has been sent out a while ago, please get a lawyer involved. Don't handle it yourself.
Okay.
Okay.
When I check my I-85 status on the USCIS, check my cases online, it says that my 2012 date when I have applied, it says a fingerprint fee has been received on April 2nd or 3rd of 2012. That's the only status as of now shows on my I-485 SRC number.
Pranavji, the problem is the online data is neither deep enough nor reliable enough for me to have any peace of mind with that. So I would rather have you follow up manually.
Okay.
Okay.
That's your time. Thanks a lot for the feedback.
You're welcome.
Yeah.
Good luck, sir. Okay, there is one more question. This is from my neighborhood, Virginia. Go ahead, Virginia.
Hello.
Yes, ma'am.
Yeah, hello.
Yes, I can hear you.
Yeah, hi. I have another question. My husband is on the line also.
Ma'am, one
actually,
second. Ma'am, 1 second. Unless your question is a follow-up on the two issues I've just discussed, you're going to have to wait.
Okay, we have to wait. Okay.
Yes, no new questions yet. Stop. Let me repeat. This is going to get a little confusing, I'm sure. I did the frequently asked questions. Then I will do all the posted questions. Once I'm done with the posted questions, I'll invite follow-up on the posted, then new questions. Okay? So please stand by. Now, let's get back. I think these were the only two frequently asked questions today. Let me just double check. And that is correct. Now, let me go back to the first posted question and see what's going on. There was a tax issue, I think, if I remember correctly. Yes. So the question is, I've got a US green card, but no income from the US in 2014. all income was from Canada. As a green card holder, do I need to file tax returns? Well, first of all, my knowledge of US taxes is so shallow, you do not want my advice. Check with a CPA. I can tell you this. If you do not, if you file taxes in US as a non-resident, they will take away your green card. That's typically the process in from the immigration perspective. And also, I will tell you this, that one of the problems, from what I remember of taxes in my tax class way back when, uh, I believe that US resident citizens, etc., are taxed on income derived from any source anywhere in the world. But typically, you don't have to pay taxes twice. Many countries have double taxation treaties with the United States. So if you have paid taxes in one place, you may not have to pay them again. But you do have to, I believe, file taxes and not as a non-resident. So please check with the CPA about what needs to be done. Let's go on to the next question. There are two frequently asked questions. Then there is Silver Mass. My question is related to EB2. You've got a 3-year degree from India, 10 plus year experience. Can I go to EB2? No, you cannot. The 10-year exception exists for those people who are exceptionally qualified, almost EB1 level applicants. So if you have a 3-year degree, my recommendation always is to file as an EB3 and start a master's degree. Once you get the master's degree, file for a promoted job or a higher job with the same employer, an EB2 level job, and redo your green card, transferring the priority date from the old case to the new case. So first do EB3, finish your degree, master's degree, then file again and transfer the priority date from EB3 to EB2 case. I have an education experience evaluation. That does not work. Education and experience combination works only for H1s. It does not work for green cards. So don't, and I can't tell you how to file the case. That's something your lawyers have to decide. But you cannot file EB2. How long does it take to clear the PERM? PERM is not dependent upon your qualifications. PERM is based upon the processing times that exist at that time. Okay. So then there is Rajesh RK001 or 01. Received my green card under EB3 more than 2 years, 2 months back. I've traveled 4 times outside USA for short vacations. Maximum time out was 8 weeks. So it was 2, 12, 4, and 8 weeks. I guess there's 12 weeks. 12 weeks outside. Okay. Well, first of all, I just want to make something clear here. You will lose your green card if you don't have your permanent home in the United States. Some indications, just having a home is not enough. Indications are you live here, you work here. So unless you have that sort of a situation, the government is well within its rights to come after your green card. Okay. So far you've been always outside USA for less than 180 days. Now you want to go for a year. Can I do a reentry permit? Yes, you can. As long as your permanent home was in USA, even though you traveled in and out, I'm not concerned. If you took a job outside USA and now are trying to get a reentry permit, you could have a problem. But you know what? This is an important benefit. Talk to a lawyer. Make sure all your various issues are covered. I can give you general guidelines, but have your particular issue examined in detail. I think reentry permit is a very smart idea. Okay. Appropriate purpose for reentry permit, whatever the true purpose is, don't make things up. One thing I always tell people to remember is a reentry permit is applied properly when there is an event horizon in mind. You must have some event horizon. I'll be back by this date. You can't leave it open-ended. If you leave it open-ended, government can come after your green card. Okay. So I'm not going to tell you what the reason should be. It should be properly drafted, properly presented, and it must be truthful. You can ask for a re-entry permit for up to 2 years. Can I change my company in India? The only thing I would be concerned about is that is another indication that you have abandoned your permanent residence in USA. If all other elements in your green card environment are conducive, I don't see any problem in changing jobs, but somebody has to examine your details. I can't tell you that in the abstract. Is it possible to use an old unused H-1B without spending 1 year outside USA? Yes, as long as you have time remaining on the H-1 and you have not used it. In your case, I did the calculation. You were on L-1B from 2007 to 2012, 5 years gone. Then you were on L-1A up to 2014. So you've already been. I went to India on March 3rd. Okay, so you came back on H4 for 3 weeks. Yeah, you have not been outside USA for 1 year, so you have no time left on your H1. Your problem is not the quota. Your problem is the 6 years. You have exhausted 7 years on L1B and L1A and not been outside USA for more than 1 year. I think H4 EAD could be an option, but H1B is not an option because you have not been outside USA for 1 year. You have exhausted your time of stay. Next question, sgoel.libra. Got I-140 approved last month, planning to apply for H4 EAD for wife starting May 26th. If I change jobs, does the EAD still remain valid? Yes. If the H-1B holder changes jobs, the EAD will remain valid. See, it's tied to your status. As long as the H-1B holder is maintaining status either with this employer or the next employer, the EAD of the wife or husband, whoever your spouse is, derivative is not affected. Okay. Will USCIS process H4 and EAD applications at the same time? And the answer is we don't know. They have said they're going to try, but they can't guarantee. So if you file H4 and EAD at the same time, they're going to try to process them both at the same time. Okay. Or will they process H4 and H1 extension first and then take 3 months to process H4 EAD? We don't know the exact sequence of events. See, right now they're having trouble even issuing EADs for other cases like 485s within 90 days, which is required by regulation. In the last meeting, ELA with the USCIS had said that they are going to try to train more officers or better train officers so that the 90-day deadline will be kept within a few months. Now, what does that mean? I don't know. So I don't know what the time frame is going to be like. There's no certainty at this time. I got my H-1B visa stamped in November. I was in USA for only 5 months. H-1B expired September 2014. Employer is planning to apply for L1. Is it possible to file cap exempt H-1B? Yes, because you have had an H-1B approval within the last 6 years. You have gotten the visa stamp. At that time, you became cap exempt. So your employer can go for H-1B cap exempt. If you come to USA on L1, another employer can apply for your H-1B cap exempt. Pay slips should not be necessary because H-1B pay slips are only necessary when you're trying to prove status. Okay, so pay slips or pay stubs or previous proof of having worked continuously, it only goes towards your status. It is not a requirement to be quota exempt. Okay. And yes, any employer can file for an H-1B quota exempt for you at any time now. Rahul 11J, EAD H4. Okay. Visa stamps are expired, but want to travel while the H4 EAD is pending. I've mentioned this several times before. USCIS has said they're not sure whether they are going to allow travel while the H4 EAD is pending. Allow travel means if they disallow it, you would lose your pending application. You'll have to apply again. Okay, so that's not the end of the world, but simply means double expense and double delay. There is no premium processing for H4 EAD. Okay, so we don't know what their stand on this is going to be, whether they are going to allow travel or not. Next question is Amit Ranjan. Thank you, Amitji. You have kind things to say about us. We appreciate it. Uh, First question is, I'm an H-1B employee, 1.5 years of H-1B gone. Spouse is a BCom, 3 years, also a chartered accountant. As a 3-year holder, could she qualify for an H-1B? No, not unless she has at least 3 years of professional experience. If she does, then she would. CA, chartered accountancy from India, has been a little thorny subject. Maybe it would qualify somebody, maybe it won't. For green cards, it is definitely not considered to be equivalent of bachelor's. But for H1, you might be able to make a case. I don't recall the last time we ran into this issue. It's been a while, but I did a few consultations in the last couple of months on people who had filed based upon a thinking that this should be considered to be equivalent to a US bachelor's degree. And it's problematic. Company secretaries, the cost accounting diplomas and or the training, etc. All of these are troublesome. So don't depend upon it, but certainly worth a shot, especially if she has 3 years of experience. If my employer files for green card and I get my I-140 approved, would she get EAD with her H-4 or would we have to wait to complete 6 years? My employer's immigration attorney advertised the H-4 EAD criteria in this way. They're wrong. They're wrong. You have to meet one of the two criteria. Either your I-140 is approved or you are getting 1 year extension past your 6 years based upon a labor cert that has been filed a year ago. So those are one or the other. Okay. Let's see. Then you have another question, Amiji. EB1 International Manager category. So one of the things that your lawyers told you is that if you travel outside during your L1, that time can be aggregated to form the 1 year service required outside the US. I think they're wrong. I haven't looked into this issue specifically for a while, but if I remember correctly, and I could be wrong on this marginally, but I think I'm right, USCIS has said that the 1 year work outside the USA should be pretty much continuous. You can't aggregate, I was gone 1 month, then aggregated 6 months later with another 1 month. You can't just do that. It's gotta be full 1 year continuously outside USA, as far as I know. Of course, lawyers, IT professionals, engineers, doctors, we all have to look things up. Nobody knows the entire field of their knowledge offhand. But when you have been working as long as I have, you tend to accumulate things. And I do not believe your lawyers are correct. So they may be well respected, but in this sense, these two instances, I think they are either making a mistake or maybe you are misunderstanding them. Also, if you are managing people outside the US, for odd reasons, the government does not consider that to be a managerial position. So they discount those. Okay. I don't know what your case is, but from what you have described to me so far, it does not appear to be that the case that you're getting good advice. I think it's incorrect advice. Naveen Chakoti, wife is on EAD, AOS is pending based upon my 485. I've gotten an NOIR, Notice of Intent to Revoke. So, planning to apply for a new H-1B for her under the new quota. That's a smart idea. Absolutely. H-1B does not impact her EAD. Go ahead and get the H-1B filed. You can apply for consulate processing. You're not going to get change of status anyway, unless she's on H-4. Okay. Change of status is only given to people who are already on H-4. So when you apply for her H-1, she is going to have to go outside USA to activate it. It does not affect her EAD. If your green card is approved, the H-1B does not interfere with it. Don't worry. So if I get my green card approval today and the H-1B gets approved day after tomorrow, it's not going to overrule the green card. Don't worry about it. If my I-140 gets revoked, will she get H-4 EAD based upon my 6+ years of H-1B, even though I'm without a current approved I-140? I don't think so. Because if you get 3-year extension based upon I-140 approval, you are not covered by the H-4 EAD rule. Only people who are getting 1-year extension. I think government had it in the original draft that as long as you're past 6-year extension, doesn't matter how you got it, we will give you H-4 EAD rights. Then they went back and changed that, thinking of it as being unnecessary, not realizing that circumstances like this, we might need it. So it is my opinion, at least so far from what I've seen the government say and write, you will not be able to get H-4 EAD if the I-140 is revoked and you are not covered by that 1-year extension rule past 6 years, okay? Harman Gill, currently on H-1B, MS degree from US, same company, 3.5 years, started as a contract employee, 1-year experience in India. According to employer's lawyer, job requirement is not for MS degree or 5+ years experience. They can't file EB2. I agree with them. If the job does not require that, please start EB3 right away. That's a very important benefit that gives you many gifts that would not exist without a green card. And you can always get the promotion done later on and convert the case to EB2 by refiling another case. So yes, my advice is start the EB3 as quickly as possible. Mani Shankar, Mani says, I'm on H1 since 2008. Wife is also on H1 since December 2013. My wife can get an EAD under the rules, so we are taking that as a given. Can we apply for H4 and EAD together? Yes, you can. If she can apply for H4 and EAD together, will she receive H4 and EAD together approval as well? And the answer is we don't know that. I just said that. How it will impact on her current work status. My only concern is if USCIS staggers the H4 and EAD. She's on H1, you filed H4 and EAD. H4 got approved, now she has to stop working because EAD is not yet approved. So she'll have to have a gap until the EAD is approved. That's the only concern I have. Next question is Kumar. 2 questions with regard to filing H4 EAD. Approved I-140 EB2. Oh, under how to fill I-765. First of all, I do not know if the government has published the new I-765. I know that there was a draft posted. It's in one of my tweets. By the way, guys, I need to mention this to you. My Twitter account is fairly active, immigration.com, no dot. And so is our Facebook page and our apps. All of that, you can go to immigration.com homepage. On the top right, you will see all our social media links. Connect with us. I highly encourage it. Okay, then what documents do I need? All of these things have to wait until we get the final I-765. If you're on the phone, Kumar, confirm for me if the new I-765 has been published. I don't think it has. And if you go over my tweets, somewhere somebody had sent me a link to the proposed draft 765. In that, they had created a special eligibility category for spouse of H4EAD. So we need to wait till that becomes final. They'll also have instructions with that on what documents you need to submit. What you are thinking appears to be right, that you know, proof of H-1B status, proof of marriage, pay stubs, etc., etc. I think that is generally the right thing. And where are you going to file? All of that is up in the air. Until we get the final forms and final instructions, I cannot answer those questions. Clin 3845, working for employer X, got a job offer from a company A. H-1B transfer was initiated but got an RFE. Now he wants to transfer to company B. remember that still working for X. Yeah, you can. That's not a problem. And if there's an RFE gets denied from company A, no problem. You're still working from company X. So if the A H1 gets denied, it does not affect your B H1B. If both get approved, you get to choose who you want to work with, but it doesn't overrule, one doesn't overrule the other. So these were some of your generic questions. Let me go over your questions one by one. Can I apply for H1B transfer to company B? Yes, you can. What information do I have to share with company B? I think you'll have to tell them, I don't know, look at the form I-129 and supplement H. Whatever questions it asks, you have to answer those questions. What if company B petition approves last? Doesn't matter. What if company A approved last? Doesn't matter. Order doesn't matter. What if rejections of both petition and company X has not initiated the revocation of the H1? Can I still apply for transfer? So if you move to company B, can you come back to X? You'll have to go outside USA, get a visa stamp, and come back, in my opinion. Or if the time for company X is over or they have revoked, they'll have to reapply for your H1. But yes, you can always come back. And if you are out of status once, to come back to company X, you can't join them with the receipt alone. That's a little chancy. There is some leeway there, but you need to talk to your lawyers. My advice to you would be to continue working with company X until one approval comes through. Vaibhavi Parekh wanted to know the procedure for AC21. I have already covered it under the frequently asked questions. That was the first topic I discussed today. AB5 wants to know H4 EAD rule. I've gotten approved I-140. My wife can get H4, or my spouse can get H4 EAD. We plan to visit India. Is it allowed to visit outside the country while EAD is pending? I already discussed this. It's not clear. We don't know yes or no. Can she open a business and work for an employer on W2 or 1099? Yes, she can. Can she work for more than one employer? Yes, she can. Can she get multiple W2 1099s? Yes, she can. EAD, you can pretty much do anything that a green card holder or a US citizen can do as far as your employment is concerned. If I move jobs after my wife gets H4 EAD, can she still maintain the EAD as I have to reapply for my labor? As long as the I-140 is not revoked, as long as one I-140 is in play, I don't see any problem. Pranab, your questions I've already discussed. Now the last two questions, and then we'll start with follow-ups on these questions, and then we'll do new questions. Mahesh Parekh, job change with approved I-140 but expiring H1 in 8-9 months. Will I get 3 years extension based upon approved I-140? Yes. If you transfer your H1, your new employer, even though the I-140 was approved through a previous employer, the new employer can get 3 years of H1 as long as the old I-140 is not revoked. Once you get the H1, I do not believe even the revocation affects you. You got your 3 years. Okay. The only thing I'm a little unclear about what the government is going to do is this. So if you have 9 months remaining on your H1 and you apply for H1 transfer, will you get 9 months or 3 years? And I would certainly like to believe that it's 3 years, but government has been a little inconsistent when you apply more than 6 months ahead of the time your H1 is expiring. So if you applied in 3-4 months, when you only have 5 months remaining on your H1, you are certain to get 3 years. Okay. But if you apply this early, I do not know. I would take a chance if I were you. File premium processing, apply for 3 years. Let's see what happens. Ashish wants to know, this is the last posted question. Yes. My I-140 EB2 was approved in June 2011 with employer A. I joined B using AC21. I've got my 3 years of H1, good till 2017. B has not starting my perm, and they may not start soon. My H1 is good till 2017. Will B be able to extend beyond 2017 if they don't start my perm? Yes, as long as Employer A does not revoke your I-140. Employer B can get you your 3-year extension again. Should I find another employer who's willing to process my perm? I think it's a good idea. Will the new employer be able to request 3 years extension along with the transfer? Yes, in most cases. But once again, like I pointed to you earlier, if there is more than 6 months remaining on the original extension, they may only give you what is remaining rather than 3 years. Not sure. They have not been consistent in that practice. I don't know if my I-140 was revoked. If your I-140 status is uncertain, I would put all my efforts in making sure the employer B files for my perm as quickly as possible. Because if the I-140 is revoked, that takes away your right to get H1 extensions. Okay? Any follow-up questions? No new questions, only follow-up questions on that which was posted and discussed. Press *5. I've got one already. Press *5, 2, 3, 4, 5. Okay. So follow-up questions on what has been posted. 6 people have raised their hands. 6. Okay. Let's get started one by one in the order that you logged in. No new questions, folks. I'm not dealing with new questions. New questions at the end of this round. So if you are asking a new question, press *5 again so you can put your hand down. No new questions. Okay. Our neighborhood, Virginia, go ahead, please. Virginia. You are.
Hello?
Yes, ma'am. Go ahead.
No, it's okay. I mean, I will ask her later at the last.
Oh, you have a new question? Okay, I'm putting your hand down, okay? Sorry, guys. I have to maintain a certain order, otherwise it becomes very difficult to be orderly and do things efficiently. Okay, somebody is calling from either a Skype or a blocked number, so I don't know. You called about 45 minutes ago. Say hello. Say hello. I don't know what your phone number is blocked. Okay, let me go on to the next one. This is New Jersey. New Jersey, go ahead, please.
Yeah, this is Pranav here. I have a couple of questions on my same case. Now, I heard in the forums that when we have this kind of situation, they are putting an RFE on the yearly renewals and etc. I just want to know, have you ever got this kind of cases, or how are these kind of cases possible?
Let me check. Okay, let me check with my office. I should be able to find. Sumanji, I'm on my community conference real quickly. If I have filed, if I have taken advantage of AC-21 and changed my employers, something is wrong. Let's say my I-140 is revoked by the old employer. Do they raise this issue during an EAD renewal, or does that come up later? Because this gentleman on the phone, Pranav, is saying that he's heard from people in the forums that even during EAD renewal, they sometimes raise this issue. That was not my understanding.
I don't think so. We've never heard any such thing, but they do issue an RFE if it's revoked later.
Yeah, that's what I thought. They issue a notice of intent to revoke. Yes. It's not a part of the EAD. Right. Can you double check with Prernaji, Bhartiji, anybody in the office who does these EADs all the time? Yes. And double check them and just, I guess, poke your head in my office. Yes. Okay. So Pranabji, I don't think that is an issue.
Okay. So now next thing is that if something really goes bad, what are the situations? Because I'm not on H1 right now, but I do have the EB3 which is associated to my 485. Can we, using that EB3 application, can we apply again for 485 date comes up and etc.?
Oh, absolutely. Just because your 485 has been destroyed does not take away your EB3 case. As long as the job and the employer is still around, you can always file 485 again. No problem at all. I don't think you're going to have any problem, Pranabji.
Okay. So now one more quick question is, like, if I want an H1 right now, can I use any of these approved 140s and get an H1? Do I still need to go for a new quota,
cannot use the I-140 that was revoked, but you can use the I-140 that's still in play. You can get an extension, and quota is not an issue for you. Okay. Sumanji just poked her head into my office and said, "We have never had this issue. When an EAD is applied for, they don't raise the AC-21 merits usually."
I'm sorry, your voice was not clear for the last sentence.
The information that I gave you was correct.
Okay.
In EAD, they don't raise these issues. At least we've never seen it.
Okay, so EAD will not be an issue, but just in case if there is an issue, it will be only when my 485 is touched, or they're trying to evaluate if the number is available or not, right?
I don't know.
So
I don't know the timing. Hang on. I can't tell you what the timing of the AC-21 poke to you would be. It could be any time, but it's not a part of the EAD. And one thing that triggers it is the I-140 revocation. Okay? Pranab?
Okay, so yes.
You're going to have to make it quick.
What I understand from you is that I might get a problem or a notice or anything from the USA department anytime, but it will not be affected to my green card EAD which is right now. And the next thing is, when we get that, the only chance is that we need to provide them AC-21 documentation, right? Saying that I'm a new employer.
That appears to be a correct summary of what we discussed. I gotta go on. Okay, good luck.
Okay.
Okay, let's go on to Pennsylvania. Pennsylvania, go ahead, please.
Hi, Rajiv. This is question number 16.
Glenn 3845, RFE worked for, or you're working for X, A applied for your H1, got RFE, you're thinking of B.
No. This is for question number 16. Sorry. This is regarding the H4 EAD.
Oh, I'm sorry. I made a mistake.
Kumar
I made a mistake. Kumar 2015.
Yeah, that's right.
I-140. Oh, you wanted to know what supporting documents. I don't know any of that. Did you see if the new 765 has come out?
I don't know whether that is new, but when I searched in the Google like H4 EAD, so I got a link like it says like I-76, there is like 4 links.
It should
and
have.
One of those I saw the instructions for 175.
Just go to uscis.gov. Look at what 765 version they have.
Oh, okay. Okay, the version number, I need to check for the version number, is it?
It should tell you when it was approved. If it is anywhere earlier than 2015, then it's not the right one.
It said like it expires on 04/30/2016 on the top right hand.
That is not what I'm looking for. I'm looking for the OMB approval date.
OMB number 1615/0040.
Approval date. OMB approval date. Hang on. Let me see if I can pull this document.
Okay, thank you.
1 second. Instructions form I-765 OMB 1615/0040. Let's see. I don't think this is the most recent one. Who may file this one? Because I remember there was an additional on the right hand side there was an additional entry for H4. Who may file I-765? Let's look at the instructions also real quickly. I don't think this is the most recent form. I don't think it's been published yet. We go.
Okay.
Give me one second.
When do you think that the new one will be out?
Give me 1 second. Who may file I-765? Asylees, some particular nationalities, TPS, foreign students, NACARA, okay, J2 spouse, M1. No, I don't see anything for H4 here. E2, L1. Nope, nothing here for H4. At least I didn't see in my real quick review that I did. I don't think they have the new form out yet, and I don't know when it's going to be out.
All right, so I will follow up your tweet, and maybe once it's out, can you please post it?
Of course, you can always tweet back to me, and if you find a link to the newest, not the ones that are floating around, but once it's on USCIS website, you can send me a link and I'll confirm it for you. Obviously, if it's on USCIS website, it is the most recent version, but you can always double check with me, no problem. Okay?
Okay, sure. And also the follow-up the question number 10. I also have the same situation. Like another friend asked us one question that I'm going for India for like 3 months, like from June. So is it advisable to file H4 EAD, or I should not file until I come back?
Too early. Ask me closer to May. We will have these answers. Right now, we don't. Okay.
All right, Rajiv.
Good luck.
Okay.
Okay, let's go on to the next one. This is Louisiana. Louisiana, go ahead, please.
Hello, Mr. Rajiv. Thank you for taking my call. I missed out asking a question. It is question number 4, Geo 2008.
1 second. 1 second. Yeah, I have a very lengthy discussion in the beginning of this call about AC21. I am not going to repeat that discussion.
No, it's not about the discussion.
Yeah.
It's about raising the service request. Do you think it is advising? The impression I got from reading the online material is beyond after 6 months for 485, we can raise the service request with USCIS, but that may affect the processing time and push you back in the line. That's the impression I got from the online material. I just want to take your advice and your opinion on that.
I am not. It used to be many years ago when this could have been an issue. I am not aware of any reason why your time should be pushed back just because you made a service inquiry. So no, sir, I don't think that's true.
Okay, thank you. We appreciate it.
You're welcome. Good luck.
Thank you.
Okay, now I have 2 raised hands left. One of them is not talking. Say hello. You are a blocked caller. So
hello.
Yes, sir. Go ahead. I've been waiting for you. Go ahead, please.
I'm sorry, Rajiv. This is Prem. Namaskar.
Namaskar.
Actually, I'm in a United States right now. Me and my wife came in the United States.
Premji, 1 second. You are a new question. I'll ask you to hold for a minute, okay?
No, it's a follow-up. It's a follow-up. This is question about the labor in 140.
What question number are you?
No, I'm not in. It's already 20. Question is gone, so they don't allow me to post any new question.
Okay, go ahead. I'll answer. I don't know what you're talking about, but go ahead. So you are in USA, all right?
Yeah, me and my wife came on a F1 visa and then converted in a H1, and my H1 gonna be finished in September 2015, September 24. And my employer filed for my H1, my labor on September 14th. But last Monday we got audit from DOL. So in that case, what is advisable to wait for the audit finish or go for new employer to apply for labor and then green card?
Okay, Premji, audits, जैसे मंदिर में जाओ प्रसाद मिलता है ना, तो when you file perm, you get audit in almost 40 to 50% cases. So audits are a fact of life. Good lawyers, when they file a perm application, file it with a predetermination that this case will be audited. So you always prepare for an audit. And if your lawyers are good, competent lawyers, they would have already prepared for it. I would not worry about the audit. They are not to be taken lightly, but it does not mean just because you got an audit, you lost the case.
Oh, okay.
But I don't know what the audit is about. To be fair, since I don't know how serious the audit is, I am just giving you a general opinion. I mean, for all I know, your audit could be a serious problem. But normally, audits are just a fact of life for us.
Correct. The audit take, sometimes is a whole year to finish and then go for I-140. So what do you think is it advisable to go for, new employer for, ask for a I-40 or labor application for us?
I would like for you the best of the two worlds. What I would like is for your employer to respond to the audit. They should be doing that anyway, because if you withdraw your perm application once an audit is issued, it's just a bad idea. I would like them to continue the audit, and you can also start a new green card with another employer.
Correct. And one thing is that we are H1 is finished in 5 months and 23 days. So it is available to change H1 employer in this scenario, or it is available to afterward in September.
Oh, you can do it even now, because when was your labor cert filed, Premji?
September 14th, 2014.
And when does your current H1 expire?
It's 6 years expire in September 24th in 2015.
So that means you are now eligible for a 1-year extension. Yeah, you should. You can go ahead and get your 1-year extension even now.
Because and they're gonna be. No, I can certify it in a few months, or it's gonna be take a longer time.
I don't know how long it's gonna take for the perm. I can't guess that.
Correct.
Okay.
Okay. So you think so? Is it advisable to change employer, because I get the new offer and little better money on that one? So it is advisable to just change a H1 employer right now, because my H1 employer and green card employer is the same.
There are two things.
So I can change.
There are two things I would recommend. One is keep the present green card going if you can. Second, change employers only. File H1 premium processing. Change employers only after the H1 is approved. Okay, that way you got 1 year, 4 or 5 months of H1 left, and at the same time you got this green card going, and hopefully you have enough time to file a second green card as well.
Okay.
All right.
Okay. Thank you very much.
Rajiv.
Thank you.
Good luck, sir. Okay, let's go to the last raised hand, and then we'll start new questions. And this is from California. California, go ahead, please.
Hello, Rajiv. Thanks for taking the call. My question is the last one. I don't know what the number is, but it is from Ash123456.
Give me 1 second. Give me 1 second. Let me get to that. And you are Ash123456. I-140 was approved with employer A, joined B, AC21. They're not filed perm. We don't know if they will. Good till 2017. Can B extend my H1 beyond 2017? Yeah, okay, I got it. Go ahead.
Yeah, so I heard your answer the first time that B can extend as far as my employer A hasn't revoked the 140. So I wanted a clarification. Is it revoked or withdrawn? So let's say employer withdraws it. Is it same as revocation?
No. Technically, once an I-140 is approved, as far as I understand, you can't withdraw. You have to revoke. Withdrawal is possible only when the I-140 is not yet approved.
Okay. Got it.
So it doesn't matter. Let us not get confused by the nomenclature. The idea is if the employer instigates the cancellation of the I-140. That's what I mean. Whether it's revoke or withdrawal, let's not call it any names. All it means is employer is stepping forward and canceling your I-140. That's the bottom line.
Got it. So let's say if I assume worst case scenario here, and it is already withdrawn, then employer B cannot extend anymore, and the same with employer C or the new employer, they cannot ask for extension, but they can still use that H1 which is already approved till 2017?
The answer is a qualified yes. Yes, that if the I-140 doesn't exist, it can no longer be used for further extensions. And yes, that which has already been given to you for that one employer will not get taken back. But if you try to transfer it, you won't be able.
I would be able to do it, right?
No transfers. But you will keep whatever has been approved for whichever employer it has been approved for.
Got it. Thank you. And the last question is there a way for me to check the I-140 state? I mean, whether it's revoked or not?
You cannot. I-140 is the employer's application.
Got it.
Okay.
Okay. Thank you, sir. Appreciate your time.
You're welcome. Okay. Any questions on any issue, new, old? Press *5 on your phone, please. Any questions of any sort? Okay. We have just three new people. *5, folks. Three new people. Okay, 3 only. Somebody put up their hand and put it down. Okay. All right. Let me start with. You had your hand up all this time and then you put it down. Let me put you out first. From my neighborhood, you had your hands up a couple of times.
Yeah,
This time you didn't put it up, so I remember your hand. So I'm asking.
Yeah, hi Rajiv.
Hello.
Yeah, hi Rajiv, sir.
Yes, ma'am. How are you?
Hello.
Yes.
Yeah, hi, I'm fine. How are you?
Good.
Now,
good.
this is my new question. Okay, actually, I'm from Virginia. I'm staying in Virginia, and my husband, he's back in India.
Okay.
And I'm a U.S. citizen, and I have applied for. I have sponsored my husband, and his IR1 visa has been rejected in Mumbai on December. It was in December 2014, and I have.
It was not rejected. Hello. It was not rejected.
Not rejected, but it was denied. As because I do not have sufficient domicile proof, and I came back right now in US. I mean,
It was rejected under section. Tell you, it was rejected under section 212A4.
212A4. I don't remember what that section means off the top of my head. Give me 1 second. Let me double check.
Rajiv, the thing is that the interviewer told me that my wife is not having enough domicile proof.
Yeah.
That's the reason I've been given one.
Yeah. No. Hang on. I understand what the problem is. The problem is 212A4 is about public charge, which means affidavit of support. What they are saying is anybody who files an affidavit of support must be domiciled in the US. Therefore, the affidavit of support which was filed by your wife could not be accepted because she does not live in the US. Okay, now I think what you should do is to probably get a lawyer and let the consulate know that the case should be reopened immediately, because the sponsoring spouse, who also gave the affidavit of support, has now moved back to USA. Therefore, there is no reason not to accept her domicile. See, it's not required that domicile must have been established 10 years ago. All that is required is when the application comes up for interview, somewhere along that time, either she is already back in USA or she's looking for a job in USA or she's in the process of moving. If she has already moved, go ahead and reopen the case.
Yeah, I'm moved.
I think that will work.
No, Rajiv, I have moved. Okay.
Hold on. Rajiv, the other thing is that she has moved back to USA, say a month back, and she had been staying here in India. The problem is that we need to start a family, right? So these are some of the reasons because of which she was removed.
Reasons, hang on.
These reasons
Sir, reasons are irrelevant. In your particular situation, you don't need to worry about reasons. Okay? Only thing you need to.
Rajiv sir, please, my question is, how can I give the proof for the domicile, and what do I have to do? Because it's saying that in the letter that he has to drop some documents. In within 1 year, he has to drop some documents, and even my father has showed a lot of efficacy. My father and mother, my parents are staying in US. They are working also. I'm looking for a job at this moment, but I did not get any job yet.
Okay, ma'am. I don't want you to do it yourself. Get yourself a lawyer.
Okay.
Let them handle it.
Mm-hmm.
This is not a difficult situation. Okay.
Okay.
Typical proof that we presented is take it back to USA, your entry stamp on your passport, an affidavit from you saying I've moved back, some proof that you've been sending out resumes.
Okay, I got it.
Okay, it's not difficult, but it's just document intensive and it should be done right. Don't worry about it. This is not a big deal.
Rajiv, the thing is that the best possibility will be right now to hire a lawyer and they will proceed with the things.
Yeah, let them take care of it. This is just, at this time, it is not something I would want you to fool around with. You can do it, but you need a lot of knowledge and a lot of understanding. It's not something you should do yourself.
No, I have, Rajiv sir, I have also applied for credit card. I have opened one account for bank. You know, I have I also drive here, and I also got the insurance for my car. So, you know, I'm doing all these things. I'm seeking for a job also.
Yeah, you should be okay. That's
so
what
these can prove.
I just told you.
So these can prove, right? But so how many days I have to, after how many days I can do all these, you know, because I got a phone also, even phone bills.
You should, ma'am.
And all these, right?
Ma'am, all these details are unnecessary for me. Yeah, we don't need to prolong this discussion. I have already given you the bottom line. Get yourself a lawyer, you'll be fine. Okay?
Okay, thank you.
You're welcome. And don't worry, this is not something that's beyond your control. It should be easily fixable.
Okay.
All right.
Thank you.
You're welcome.
Thank you.
You're welcome. Okay. Once again, the blocked phone number, Premji, is that you?
Yes, sir. This me.
Yeah, go ahead.
Okay, sir. I forgot to ask one question. Thank you for taking my question. If I file for extension under AC-21, when I can start working with the new employer?
Premji, you don't currently have an H1, do you?
Yes, right now is H1. I am on H1 right now. It's finished on September 24, 2015. So I have 5 months and 23 days.
You can join the new employer as soon as you file the application.
Or as soon as I file, I can join. Oh, that's great.
Yep.
Okay, thank you very much. So nice of you, sir.
You're
welcome. Appreciate the help.
You're welcome. Good luck. Okay. We have 2 more questions. Let's go to Pennsylvania. Pennsylvania, go ahead, please.
Hi, Rajiv. If we apply H4 EAD, is biometric collection mandatory for all applicants?
I don't know the answer to that question. From what I understand, H4 EADs only require a picture. They don't require anything else. This is my understanding. But again, this level of detail will come out and be understood better when we have the instructions. I can't answer that question for you. I think it will be only a picture.
All right. Okay. One more question. Is it possible to use USCIS logbox facility to file I-76 for H4 EAD?
Don't know. I have no idea. Sorry.
All right.
Good luck.
Okay.
Sorry, guys. Some of these things are still a mystery. So the last question today is from Florida. Florida, go ahead, please.
Good afternoon, sir. Rupinder here.
Hanji, Rupinder, how are you?
One or two questions. I'm good, sir. Thank you so much. How are you?
Very well, thank you.
Okay. Regarding I-140 original petition paper, I have got approved 140, and I just wanted to know that my attorney says that they cannot give the original petition paper for I-140 as they wanted to file for the employer actually. Is there any issues if I don't have the original I-140 and a copy of it?
You only need a copy of the I-140 approval pretty much for anything that I can think of.
Sorry, I didn't get you, sorry.
You only need a copy of the I-140 approval for pretty much anything that I can think of. I don't think you need an original for anything. Now, except when you file 485 for the same employer. But I don't think you need a copy for anything like AC-21 or priority date carryover or H1 extension. All of them can be done with just a copy of the I-140 approval.
Okay. And does it make a difference if suppose if I change the employer? Then does it require a original petition or it's copy?
Copy only. Copy only.
Oh, copy is enough. Okay. Second question is regarding H4 EAD. That although my wife is having a H4 approval for 3 years, but still she is eligible for H4 EAD application, right?
I'm sorry. Can you repeat the question? I didn't understand. Her duration?
Yeah, my question is like my wife is having a H4 approval for 3 years.
Okay.
And she is eligible for applying H4 EAD.
Oh yes, yes. Let me rephrase your question and make it clear. So the question is, do I always have to apply for H4 change of status or extension if I already have an H4 in order to apply for an EAD? And the answer is no. If you already have an H4, you'll just apply for an EAD, whether you came in on H4 visa or you did a change of status.
And that is provided the primary beneficiary should have a 140 approved, right?
140 approved or in the 7th, 8th, 9th year of their H1 extension. One of the two.
All right.
Okay.
Okay. Yeah, and I missed one of the answer actually. To avoid for this topic. So
Sorry.
I just want to know that can my wife or I can travel on H4 EAD?
And the answer is you cannot travel on the H4 EAD. You need a visa stamp. An H4 EAD is not an advance parole.
No. What I'm saying is that if we have applied H4 EAD.
Oh yes. Okay. Got it. We do not know if government will allow travel while the 765 EAD request is pending. They could consider it to be an abandonment or they may let it slide. I do not know. They are yet to get back to us on that.
Okay, but still, if a person has an H4 EAD card approved, still that person has to have the stamping done on the passport.
That is correct. Just because you have an EAD does not take away the requirement of a visa stamp.
Oh, okay. I got it. Okay, that's what I want.
Good luck, sir. Good luck. Guys, everyone, thank you for being here. I always enjoy speaking with all of you. I'll talk to you in 2 weeks' time, every other Thursday, 12:30. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.